Good afternoon.
Good afternoon.
Yes, you have
Good
me.
afternoon.
Yes, how sad. Miss Dawson is not able to make it again. She's had another family emergency. So I'm filling in at the last minute.
We're happy to have you.
Yes, right. That's what you all
You
say
didn't,
now.
you didn't hear
Archer,
all that
that's not
sincerity.
nice. Jeez.
That was filled with sincerity.
So you know how we really feel about you. Is that what you're trying to say? I'm only kidding.
Well, I don't know. I don't know because
You making it sound like we don't like you.
no. This is the preface of what I'm about to say. I have the sad news of the one of to tell you what's on the midterm.
Sad news. Oh, well, I would have thought that would have been great news so that we could prepare. But when you say sad, that means it must be very difficult.
No, y'all probably didn't want to hear it from me.
Oh, okay. What? Okay. Okay.
Of
Okay.
course, if you wrote it, we definitely want to hear it from you.
Oh God. Anyhow,
Miss Archer, I have a good, I don't know, I've already presented a case, but I have you assigned me a really good one. So if there's time, I definitely want to do mine as well this evening. This is a good one.
okay, yeah, we can. Like I said again, because of short notice, I am not prepared like that. But
Oh, I thought you told us last week you'd be with us this week. No?
yeah, I did.
Mm.
But
Yeah.
that was a slip. Because
The
apparently,
cases,
yeah, when they said 2 classes, they meant her class the next day. And I thought they meant the 2 employment
Oh.
classes, but they meant the next day. So as far as after I did that for her, then this week she would be here. And then they called this couple minutes ago to say no, she had another emergency if I could fill in for her again. So no, I wasn't prepared for it today. But yes, I've already written the midterm exam.
Okay, do tell.
That's done. Okay, so who's going to say something just now? I heard someone. I heard a voice. Who was that?
Well, I was saying, you said you wrote the midterm exam. I'm like, okay, do tell. Let us know.
Oh, not yet. Too early.
Oh,
It's too early for that. Okay. Well, let's see. We have some cases to present.
I thought we were presenting next week.
Right. I was
Yeah.
just about to say, because I know
But
the
thing is-
22nd was, okay. So
Yeah,
I
but
wasn't-
the floor says she has one she wants to share.
Oh no, I was saying
Okay.
if we got to cases, I have a good one. I think everyone would be interested in this one.
Let's
So
hear it. Let's hear it.
you want to hear it? Okay.
Yeah. Go ahead.
All right. This is Kedra Bell versus John Bull. So this is a claim for wrongful or unfair dismissal as set out in the originating application filed by the applicant on August the 8th. States the applicant states that she was employed with the respondent for a period of 6 years and 3 months from November 2010. At that time of being hired, she signed an employment letter, which was attached to a handbook. Once these were signed, they were turned over to the store manager. She identified a version of the handbook. She further states that she was terminated at the end of 2017 and received an official letter on the 4th of February. She identified the termination letter, which she read and stated that the letters said that she was terminated because they believed that she was dishonest because she traveled while she was out sick. And then they have an exhibit of the letter. Should I go through the term letter itself, Ms. Archer?
Yeah.
Okay. Dear Kedra, please be advised that we have now completed our investigation into the matter, which occasioned your suspension. In view of the above, please be advised that your contract of employment has been terminated on the grounds that we genuinely and reasonably believe that you were dishonest. You submitted a sick slip to your manager stating you were going to be out sick for 5 days. During this sick time, it was brought to your manager's attention that you traveled to Arizona and participated in a World Ventures conference. As a result thereof, you have vitiated the trust and confidence reposed in you by the company in the performance of your duties and responsibilities. It is for these reasons that we feel that continuing your employment will not be beneficial to the company. Therefore, at this time, we feel it is in the best interest of this company that we terminate your employment, but do, however, wish you success in your future career pursuits. Your final paycheck, less any money owed to the company, will be paid on Friday, February the 17th. Your commission will be in the bank as scheduled on or before the 10th of this month. All right. You guys hear why she was terminated, right?
Mhm.
She says at the time she was terminated, she was a supervisor and was a counter or brand manager. She recalled the incident, which they referred to on that Tuesday. She left work to attend to the doctor, who suggested she take some time off and gave her a sick slip for 5 days starting from that date. She informed her immediate store manager, Allison Ferguson, and sent the sick slip in with a third party. She goes on to say that when she returned to work on the 29th of January, she was pulling into a meeting with Allison Ferguson and Dorian Roach. In that meeting, she was asked if she was out sick, and she said yes. She was then asked if she had traveled, and she said yes. She was told that she should not have traveled while she was out sick. She tried to explain that this was only the second time in 6 years that she had ever called in sick. Dorian Roach told her that was exactly why it was a problem. She was suspended for 5 days without pay and was also cut for the 5 days she was off sick. She said she did not have any other infractions with John Bull during her tenure with them, but she was given a reference letter by them in August of 2015. The letter was identified and exhibited as KB2. It gave her salary of $16.25 per month and approximately $600 commission. It also stated she was honest and reliable, and her continued employment was favorable. So they go on, there's a letter that says that from them, right? So a
Right.
nicely written letter. She then says the applicant further states that she was given annual performance reviews, but she was never recommended for any additional classes because she had already taken both the sales and management classes at John Bull successfully. Under cross-examination, she admits that the date should have been the 24th and not the 23rd of January that she saw the doctor. The sick slip was entered as KB3. And there's a sick slip from Bay Street Medical, 24th. This is certified that Keidra Bell was examined by Bay Street Medical and will be unfit to work for 5 days, effective January the 24th. Being shown 2 documents showing infractions, she acknowledged that she was aware of both instances. So in April of 2011, it stated that she left without permission. Kendra went on a break. She did not clock out, and she left the store without permission. And she acknowledges that. Well, she said, I did not leave the store without permission. I did notify my supervisors. I exited the store, and I was given a verbal warning by Mrs. Roberts. So that's on her file. Also in July of 2012, Keidra's body language was, I didn't understand this. Keidra's body language was uninviting. She did not walk off. She did not walk the customer over to the area. She had her arms folded the entire time. So I felt I guess they felt it wasn't customer service related. She arms crossed walking a client over, not very inviting, right?
Just want to do it. Yeah.
Yeah. Okay. So it goes on to say, she also states that her immediate manager was well aware of her health condition. She admits that she was out sick, but does not feel that this meant she could not travel. She was told by the doctor that she should take it easy, and so she traveled for rest. She also insisted that her traveling did not entail very much standing or walking or any strenuous activities. On re-examination, the applicant states that the 2 disciplinary reports were supposed to have been verbal warnings and did not affect her overall performance review. The applicant closed, and the respondent elected not to call any witnesses. So submissions of applicant. The applicant submits that on Tuesday, January 23rd, 2017, the applicant left work early, advising that she had to attend to the doctor. After a visit to Bay Street Medical, she received a medical certificate number 290, which indicated that Keidra Bell was examined at the Bay Street Medical and will be unfit for 5 days. The applicant returned to work on January the 31st, 2017 as scheduled, and she was pulled into a meeting with her supervisors. The applicant was asked if she was out sick and also if she traveled, both of which questions were answered in the affirmative. The applicant said that her supervisor told her that considering that she received a medical certificate, she was unfit for 5 days and should not have traveled during that time. Further, that the applicant should have been healthy enough to report to work, and the fact that she did not resulted in her being dishonest. The applicant was not paid for the 5 medically approved sick days. The supervisor informed the applicant that she would be suspended for 5 days as a result of her apparent dishonesty. The applicant received a termination letter on February the 4th, 2017. The letter indicated that you submitted a sick slip to your manager stating you're going to be out sick for 5 days. During the sick time, it was brought to your manager's attention that you traveled to Arizona and participated in World Venture Conference. As a result, therefore, you violated the trust and confidence reposed in you by the company in the performance of your duties and responsibilities. This termination letter violated the company's disciplinary process, as the applicant never received the appropriate warnings and submitted no evidence to the contrary of the medical certificate, after which a repeated infraction would lead to termination. Therefore, a termination was rushed to judgment and premature. The applicant was not paid for 5 days medical leave, which is contrary to the John Bull Handbook, which states, in the event of absence from work due to certified sickness, the company will make up your weekly income to your full base salary in accordance with the following period. After completion of probationary period and during the remainder of the first 5 days. As a result of the supervisor's claims, the applicant was advised of a 5-day suspension without pay. This is in violation of her employment contract, as this matter is not a term with respect to the medical certificate. You guys got that part? So the applicant was hired as a sales beauty advisor and was eventually promoted to counter manager up to the time of her termination letter dated February 4th, 2017. The respondent would have summarily dismissed the applicant. The grounds for summary dismissal was stated in Section 32 of the Employment Act. Further, it is the respondent's responsibility to ensure that they would have conducted a reasonable investigation with respect to the applicant's actions as provided for in Section 33 of the Employment Act. An employee shall prove for the purposes of any proceedings before the tribunal that he honestly and reasonably believed on a balance of probability that the employee had committed the misconduct in question at the time of the dismissal, that he had conducted a reasonable investigation of such misconduct, except where such an investigation was otherwise unwarranted. The respondent provided no medical evidence to the contrary with respect to the medical certificate issued by Bay Street Medical. The respondent was provided with a medical certificate with respect to her illness. The grounds for sick leave are stated in Section 11 of the Employment Act. The respondent is under a legal duty to treat the applicant honestly and fairly when making a decision to terminate. The respondent is under a legal duty to adhere to the statute laws of the Commonwealth of the Bahamas as it relates to the applicant's employment and should pay the applicant all statute benefits due and owed upon termination. Whether misconduct justly summary dismissal is a question of fact, and they cite Neary and another versus Dean of Westminster. The question will always arise, what degree of misconduct justifies summary dismissal? In Neary versus Dean Westminster, Lord Jauncey of Toulouse says, gross misconduct justifying summary dismissal may be seen as conduct so undermining the trust and confidence which is inherited in a particular contract of employment that the employer should no longer be required to retain the employee in his employment. He then quoted a statement by Lord James of Henford and Clauston and Co. versus Corey, where he said, now the sufficiency of the justification depended upon the extent of the misconduct. There is no fixed rule of law defining the degree of misconduct which will justify misconduct. Of cause, there may be misconduct in a servant which will not justify the determination of a contract by one of the parties to it. On the other hand, misconduct inconsistent with the fulfillment of the express or implied conditions of service may justify dismissal. Where do you guys think this is going?
I picked this one just for you.
This was just for me. I like this one. What do you guys think? Is it like, don't you see where it's going, right? Gonna be a twist. You ready? Okay.
Yeah.
Respondent submissions. The respondent submits that the applicant signed acknowledging both the company handbook and policy and procedures manual. She confirmed signing same during tribunal and indicated that copies of the manuals were at the store location. The acknowledgement states, I further understand and agree that I'm expected to abide by the rules and policies in the manual, as well as changes made hereto to management from time to time. I realize my failure to do so may constitute cause for dismissal at any time with cause. Dr. Tennille Cargill issued a sick slip for 5 days indicating she was unfit to work. The company can draw a reasonable inference that the intent was for her to be on bed rest to recuperate. However, the very next day she traveled to Arizona. The travel time for this journey is approximately a little over 7 hours. This does not include the time to be processed in a minimum to airports and layover time. Thus, she would have been traveling and not resting to recover for almost a full day. The company contends that she would not have been the intent when the company contends that this would not have been the intent when given the sick days off. Upon confirming with our doctor, Martin Brown at Kennedy Medical Center, for general information, we are advised that when a sick slip is issued for unfit to work, especially for more than 3 days, it is the intention that the person should be on bed rest to recover for at least the first few days. Ms. Bell traveled the very next day after being issued a sick slip, approximately 2 p.m. the day before, January the 24th. She thus had to make immediate preparations for a travel, giving the impression that she, in fact, did not need any time to rest or start her recovery. During the tribunal, the applicant, via her lawyer, made reference to her receiving a favorable reference letter. Despite having 2 prior disciplinary actions in 2011 and 2012, however, this reference letter was issued in 2015. As per our policy 3.1 section C, the company always reserves the right to deem a contract repudiated upon the single occurrence of any prohibited act. As such, her past performance does not exonerate her from being disciplined for future infractions. Additionally, as per the same policy, section D, the ability of the company to exercise its discretion on a case-by-case basis is paramount. We further submit that the applicant was suspended without pay in accordance to our company's policy. Upon investigating all the information gathered, the company honestly and reasonably believed on a balance of probability that the employee had committed the misconduct in question at the time of the dismissal. The issue is whether the applicant was wrongfully dismissed. The law states, at common law, wrongful dismissal occurs when 2 conditions are fulfilled. Firstly, the employer must have terminated the contract of the employment without notice or with inadequate notice. Secondly, there was no justification in terminating the contract of employment. In order for there to be a lawful termination, there must be reasonable notice or reasonable pay in lieu of notice. This is the common law position. In Betty K. Agencies Limited versus Suzanne Frazier, Court of Appeal of the Bahamas sets the rules that where statutory provision exists, case law can only be a guideline as to the possible meaning and interpretation to be given to the statutory provisions. Section 31 of the Employment Act provides that the conduct which must justify an employee's summary dismissal must be such as to amount to a fundamental breach of his conduct or is repugnant to the interests of the employer. So notice is determined under Section 29(1)(c) of the Employment Act. For the purposes of this act, the minimum period of notice required to be given by an employer to terminate the contract of employment of an employee shall be A, where the employee has been employed for 6 months or more, but less than 12 months, 1 week's notice or 1 week's basic pay in lieu of notice, and 1 week's basic pay or part thereof on a pro rata basis for the said period between 6 months and 12 months. B, when the employee has been employed for 12 months or more, there's 2 weeks notice or 2 weeks basic pay in lieu of notice and 2 weeks basic pay or part thereof on a pro rata basis for each year up to 24 weeks. Where the employee holds a supervisory or managerial position, 1 month's notice or 1 month's basic pay in lieu of notice and 1 month's basic pay or part thereof on a pro rata basis for each year up to 48 weeks. Sections 31 to 33 of the Employment Act speaks to summary dismissal in instances of misconduct that is contrary to the fundamental interests of the employer. An employee may summarily dismiss an employee without pay or notice when the employee has committed a fundamental breach of his contract of employment or has acted in interest of the employer, provided that such employee shall be entitled to receive previously earned pay. 32, subject to provisions in the relevant contract of employment, misconduct which may constitute a fundamental breach of contract of employment or may be repugnant to the fundamental interest of the employee shall include, but shall not be limited to the following: A, theft; B, fraudulent offenses; C, dishonesty; D, gross insubordination or insolence; E, gross indecency; F, breach of confidentiality; G, gross negligence; H, incompetence; I, gross negligence, H, incompetence; I, gross misconduct. 33, an employer shall prove for the purposes of any proceedings before the tribunal that he honestly and reasonably believed, on a balance of probability, that the employee had committed the misconduct in question at the time of the dismissal, that he had conducted a reasonable investigation of such misconduct, except where such an investigation was otherwise unwarranted. So with Neary and another versus Dean of Westminster sets the test for summary dismissal at common law as conduct so undermining the trust and confidence inherent in the particular contract of employment that the employer shall no longer be required to retain the employee in his employ. 37, the test for wrongful dismissal is whether the employer's decision to terminate was reasonable in light of the circumstances. So in British Home Store Limited versus Burchell sets guidelines for consideration of case summary dismissal given in the form of the following questions. 1, did the employer believe, as distinct from merely suspecting, that misconduct had occurred? What do we think here? I think when we go through these questions, it's interesting. So 1, did the employer believe, as distinct from merely suspecting, that the misconduct had occurred? 2, was that a reasonable belief in the light of what was known to the employer at the time? 3, was it a belief arrived at after as much investigation as was reasonable in the circumstances? And 4, was it reasonable to dismiss, having regard to the gravity of the misconduct which the employer believed had occurred? I feel like all of these were yes. You want to weigh in here, Ms. Archer, before I keep going? I like you always want us to keep going, but please give us your thoughts. Given what you've heard, 1, did the employer believe, as distinct from merely suspecting, that misconduct had occurred? Yes, right?
Yeah, the employer did, yes.
So 2, was there a reasonable belief in the light of what was known to the employer at the time? Yes, right?
He had a reason.
At what time?
At the time they realized that she traveled, like they got a sick note thinking she's out sick,
Yeah,
realized that she traveled, right?
and their argument is if she is sick, she should be home here in Nassau.
So that's a
Right.
reasonable, but I think
She
that's
should
a
be in bed.
reasonable belief. I'm just saying reasonable.
Yes,
Yeah,
Yeah.
right?
because if someone calls and they say they're sick and the doctor give them 5 days off, you don't expect to meet them at the airport getting ready to board a flight. The first
Right.
thing is
Right.
they're not
Unless you're
sick.
going to seek a second opinion. Exactly, right?
Exactly what can happen.
Okay, 3, was it a belief arrived at after such investigation as was reasonable in the circumstances? I think yes, too. You know, the
Yes.
doc, they even got their own physician to say, it's reasonable. Like when I give someone a sick note, we think at least the first few days they're resting, right?
Agreed.
And 4, was it reasonable to dismiss, having regard to the gravity of the misconduct which the employer believed had occurred? So was it reasonable, do you guys think, to dismiss her after realizing you do
I don't-
not? Okay.
Yes, definitely.
You
I
think
don't
they should?
think so either. I don't think so.
I don't think so.
You don't think they should
I
have
think
termed her?
so.
That's what you guys are saying?
Yes.
You do not
I-
think she should have been termed? Okay.
She should not have-
Okay. So on the facts and evidence given, the applicant was terminated for traveling while on sick leave, which was considered dishonesty on the part of the applicant. Sick leave is assigned in Section 11 of the Employment Act. An employee who has been employed for at least 6 months is entitled to 1 week sick leave with pay in any year, where he is prevented by illness from performing his duties at his place of work. Provided that no employee shall be entitled to receive payment in respective periods of sick leave, which is only 1 day long, nor to accumulate such leave from year to year. 2, every employee shall be required to produce by his employer a medical certificate, except in respect of the first day's sick leave for any period of sick leave, provided that notwithstanding to proviso in subsection 1, an employee shall be entitled to receive payment in respect of the first day's sick leave where he presents a medical certificate to his employer. 3, an employer may, on processing a claim for sick leave by an employee, require such employee to be examined by an independent physician and may refuse such leave if the physician is of the opinion that the employee is fit for work. So, and obviously, Ms. Archer, this is the minimum for the act. Companies can be more generous with this, can they not? And if not,
Yeah.
we're violating it because we're far more generous than this. Like we don't
Yeah.
require sick. We don't have someone, if you're out sick for one day, we don't make you go and get a sick note.
Yeah, this is the minimum requirements.
Yeah. So the
Nancy,
applicant,
for me- Oh, go ahead.
go ahead. No, go ahead, Ms. Burns.
No, I
I'm
was
sorry.
saying anything more than that comes under a company's benefit and compensation package.
Package, yes.
Mhm. Yeah, our sick leave, yeah. So the applicant admitted that she was on sick leave, but insists that she did not feel that this meant she was unable to travel. Her evidence is that the doctor advised her that she needed rest and she therefore traveled to be able to get the needed rest. She says she did not go to a conference as alleged by the respondent, and no evidence was presented to the tribunal to prove the respondent's allegation. The dismissal of the applicant must be fair and reasonable in all circumstances. There are also minimum procedures which the respondent must go through, including writing to the applicant in advance, inviting her to a meeting, and also offering a right of appeal against the respondent's decision to dismiss. However, considering that dishonesty is based on the merits of the facts of the case, it is important to identify the employment industry standards for dismissal. Therefore, we point out that the industry standard and identify what the respondent failed to do when the applicant was dismissed. The fact is that the respondent did not follow the industry standard as outlined in the Employment Act when they proceeded to terminate the applicant for dishonesty. In this case, the applicant received a medical certificate declaring her unfit to work for 5 days. The applicant admitted to traveling during that time and returned to work on January 31st, 2017 as scheduled. It is unclear how the respondent can deem the applicant as dishonest in the circumstances. The employment handbook also provides that absences exceeding 1 day due to illness or injury sustained off the job must be substantiated by a medical certificate forwarded to your immediate supervisor as soon as possible thereafter and on a regular basis in the event of a long-term illness. With respect to the dismissal of an employment for dishonesty, the respondent must be sure that the action of the applicant is that of dishonesty and that may have been determined had there been an investigation. Having no explanation other than the applicant was being dismissed for dishonesty is a breach of the Employment Act. This statement is legally flawed, as with respect to unfair dismissal and the remedies, Section 4 of the Employment Act states that nothing in this act shall be construed as limiting or restricting any graded rights or benefits of any employee under law, contract of employment, arrangement, or custom. In the conclusion, the respondent made attempts to avoid paying the applicant severance for the service rendered. The applicant did not deserve to be terminated summarily. Therefore, it appears that the applicant was vacated from her employment with the respondent without proper cause for termination, which is in fact a breach of her employment contract. The applicant was employed under contract for an indefinite period, and in the absence of express contractual language to the contrary, the respondent is required to give the applicant reasonable notice of his intention to terminate the contract or pay in lieu. The respondent failed to do just that. The tribunal has done extensive research on its own and can find nothing that would indicate that an employee is prohibited from traveling while on sick leave. Based on the facts before it, the tribunal is of opinion that the respondent did not comply with the necessary guidelines as stated in the cited cases. There is no proper investigation before the applicant was dismissed, and there is no evidence of dishonesty, as was the reason stated for the dismissal. The respondent submits that they confirmed with their doctor, and it was his opinion that a person should not travel for at least the first 2 days. This was not brought out in evidence and is only an opinion. The tribunal is of the view that it depends on the circumstances. In the instant case, the applicant gave evidence that she traveled in order to rest. Tribunal therefore concludes that the applicant was wrongfully dismissed and she was awarded $16,000.
Okay, And I selected this one for you because remember you asked the question.
Yeah, do they ever win? Do they ever? Right. But I thought it was not, I just thought the tenets of this was quite interesting because I feel like now, I mean, I don't know how many people she told, but everyone should get 6 slips and travel to get rest. You know, I just felt it's set a precedence for this, you know? Like I just thought it was, I mean, I did not expect, I was like, why did she give us this case? This was initially, I was like, this is cut and dry. This woman, you know, was out sick and went on vacay, but
Mhm.
it's no.
And some sickness you need vacay for.
Yeah.
I
Some
had
sickness is not only the flu or the cold. There's
no,
sometimes
understood.
it's
Yeah, I had a
mental
true,
as well.
yeah, I had a true case of someone who was out for 6 months and he went golfing every day, but that was a part of his therapy. Because it was, you know, it was mentally, aggravation, you know, in terms of having some imbalances and things like that. So golfing was a part of his therapy. Now, when persons saw that, meaning, you know, in his department and in his work area, they were really, you know, put off, just like I'm sure, you know, I don't even know how they found out this woman traveled. That didn't come up. But
Somebody saw her at the
someone
airport.
probably telling them, right?
Yeah, someone saw her at the airport, and she probably, maybe before that, she probably was saying that she was trying to go to attend this seminar, and so they probably think that she just got the sick days in order to attend the conference.
Exactly. And that's the same with my case. Someone reported they knew he was at the golf course every day, right? But not knowing again that that was a part of his therapy.
Yeah.
Yeah. And then, of course, it goes back to, well, I want his doctor. You know, I mean, jokes came about, right? Related to my case, you know, I
Right.
want that doctor because I want to be on the golf course as well. But yeah, I thought it was interesting.
Yeah.
The
Because
company,
because
I
John
went
Bull,
to say,
go ahead.
I went to say the company I work for, they're saying that a lot of persons now are complaining about burnout. And they
Yes.
are getting 6 slips and doctor 6 slips to be out for a month and 2 months now.
For mental wellness. Yeah, for sure.
Yeah,
Mhm.
that's happening. On top of that, I've had some sickness in the past, and I do attend doctors in the States, and usually if there is something wrong, before I go to a doctor here, I do go to the airport and go and see my doctor in the States.
Mhm. Yeah, but
Right.
that was an assumption that they made. I
And they
mean,
made an assumption, they didn't prove their case. And to me, on top of that, the reasonable, what is it she said? Not giving reasonable notice,
mhm.
as well as what I could see their issue was.
But the logic behind it is that if you are able to travel, you are
Yeah.
able to come to work.
That's the thought. That was the thought. Yeah.
That
Mhm.
doesn't make sense to me, because you could not be well, and because you need the rest, you may not be able to rest in your house.
Mhm. Mhm.
That's another thing.
You probably
Yeah.
may want to go to a place where
I-
by the
yeah.
feet, just relax.
Yeah, I just don't think they, quite honestly, I don't think they did their homework. I felt John Bull didn't, quite honestly, you know, before, because I do feel on the surface that there was the appearance of this, right? And that's when they jumped to their conclusion. I mean, I would have certainly asked, okay, when did you, let me see when you secured your flight? Because if it was, you know, post getting the certificate, I get it. But if you got your flight a week ago, that meant this was premeditated. I mean, none of this came up. I mean, I felt it was kind of just shoddy investigation, in my
Yeah.
opinion.
So I have a question, Ms. Archer.
Yeah.
So I have a similar situation that happened, right? I had a staff that, I'm just gonna give a date. So say on Monday, the staff called in sick on Monday.
Mm-hmm.
Then on Tuesday, they didn't call in at all, right? So, you know, they're normally required to call in like half an hour before their reporting time. So around 11, 12 noon, I still didn't hear from the staff. So I picked up the phone and I called just to make sure everything was okay, because I didn't hear from the staff. And the staff grandmother said that the employee went off the island. So I was like, so I asked the grandmother, I said, and how long was that? And the grandmother said, well, he left from the weekend. So I was like, okay. So she said, is this his manager? I said, yes. So she said, okay. So he called me like about maybe an hour later and
Mhm.
he said he has a sick slip. And he brought in the sick slip. Now he told me,
Brought it in-
go ahead.
When did he bring it in?
He brought it in that same day. So he didn't physically bring it in. He gave it to another staff.
Okay, because he was still away?
That's what his grandmother said. Now he is telling me that he was sick. And he said, I'm gonna bring in my sick slip myself. So I said, like, around what time are you gonna bring it in? So he said, I'm gonna bring it up between 1 and 2. So I said, okay. So I waited. And then around 2:30, one of the other staff brought me the slip to say that he dropped it off. Now, I had referred this to HR and they said, like, we couldn't really prove it. But then, like, a month later, like this, that was like total drama, that the person that actually got the sick slip from him
Mm-hmm.
told someone else that he nearly got her in trouble. Because when I questioned her as to what time did he bring this in and all that stuff, she gave me a full story. But then she talked that she nearly got in trouble to someone else, and it happened to get back to me. But that was like maybe a couple weeks later. But in a case like that, how do you like prove? Because the grandmother said he went off the island. And I said, when he came back to work, I said, your grandmother said you went away. And he was like, he don't know what she's talking about, all that stuff. So HR is saying, like, we can really question the doctor.
You know, it's interesting because, you know, we're going back to resting in your home. Perhaps he had to get out of the grandmother's home to get some rest, maybe, and told his grandmother he was going away so that she wouldn't bother him, you know, over his friend's house.
No.
I'm just saying.
He
I'm
went-
just
he went-
saying.
Miss LaFleur is so nice.
I'm just
so
saying.
nice.
No, I'm just saying so many what ifs, right?
No,
But
I
I just
know.
left it like that.
Even with this John Bull case, I'm you know, I'm glad it's fine that she won, but I just think they should have done more to investigate that.
Yeah, but I mean, that could have been, I could take it, but then like a month later,
yeah.
and who was in cahoots with him,
Like,
Yeah.
said it to somebody else. But
I
that's-
missed that part. So he really didn't drop it off. That's what you're saying?
No, he didn't.
No, we
I'm
didn't.
sorry, I missed that part. that part.
No, but like a month later, I found out because the person who brought it in for him said to someone else that I know that she, she said, he nearly got her in trouble for covering up for him.
So was he sick or was he off the island and sick? Which one?
He was not sick. He was off the island. He just traveled.
And
And
so
we
okay, so then HR should have investigated his sick slip because a lot of doctors
Right, but at first,
fraudulent sick slips.
right, but they're saying that, because the doctor sent this note, we couldn't question the doctor.
Then you should have to your doctor, the employer's doctor.
Yeah.
Mm,
Yeah.
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 Also, you said he didn't call in sick. He called in sick one day, but he didn't.
He
Called
called in the
sick the
second day?
next day.
The
didn't
second
call in
day,
sick
he
and
didn't
he
call
didn't
in,
call.
and it was like really
Right.
late, so I picked up the phone myself to find out if everything's okay. And that's when his grandmother said he was off the island.
And
Oh,
that's
so you
like a
called the
no
house.
show, no call.
You called the house then. You didn't
I
call
called
his
the house,
phone.
right,
Yeah.
because he didn't call in, so, another manager was saying he abandoned his job. So I said,
Right.
let me check and see, because he was sick the
That's
day
why he
before.
sent in the sick slip. so it wouldn't
Mhm.
be John, you see?
Mm,
He covered himself.
yeah,
But it was still so late. I mean, half of the day is gone.
yeah.
Mhm.
And so if she didn't pick up the phone and call him, was he going to call?
Probably
Then-
not.
Job
No.
about,
Probably not.
So then would she have grounds to at least
yeah,
write him up?
Mhm. Mhm.
yeah,
And that would have been warning number one, I guess.
yes,
Mhm. Mhm.
yes.
But
Mhm.
what's wrong is, the fact that he didn't call to me, that's grounds right there.
Mhm.
It's nice that you called, but I think
Mhm.
that's grounds right there to at least give some warning.
Yeah, I mean,
Mhm.
he was
Yeah.
documented, but I was told I could not. He was documented for not calling in, but I couldn't speak to,
Him being sick,
yes.
being
Right.
off. Yeah. Yeah.
Mhm.
You all should have sent him to the doctor.
I
Mm.
agree.
You should have sent him to the doctor.
Mhm.
This time he had another job.
He was just a world traveler. He enjoyed traveling.
Oh, I
Mm.
see.
Yeah.
You don't want to work.
Well,
So when we actually have a policy now that you have to bring in a sick slip on a Friday if you're sick on a Friday or a Monday. And it's because of one of the secretaries one time saying that she was sick, and next thing you know, another person saw her at the airport getting ready to travel. But
But
is
you could
that correct though, Ms. Archer?
I
It was
because
just
I would.
one day.
So hold on. So if I'm going to travel on the weekend,
Mhm.
I must bring a sick slip. If I'm
No.
not,
If
Monday.
if you said
she
that
was-
you're sick on a Friday, say you're sick on Friday.
Yeah.
So you call in and say that you're sick. So when you come in on Monday, you're expected to bring in a sick slip. And the same
Even
thing
though it's
goes
for one
for-
day,
even
For
though
one-
it's
but it's
one
just for
day.
one day.
Yes.
You don't have to. You don't
And
have to if it's just
and
for
it's-
one day.
no,
That's what's in the
one-
policy.
Mm.
Is that correct?
But because you're saying
Oh.
because it's closer to the weekend.
so what that have to do with it?
They just feel
Yeah,
that
that don't have
they-
nothing to do with
they-
it.
and that's
No.
the
That don't
thing.
have anything to do with it.
That's what I'm thinking, but it's just the thought that people just want to take an extended, have a long
weekend.
weekend.
A long
Right.
weekend.
Right.
But you don't have to bring in a sick slip for just one day.
Oh,
Mhm. Well, the thing is, if you signed on the handbook and that's what's in the handbook, then that's mean you're in agreement, correct?
Yeah. Yeah.
yeah, but
But I thought it was a law thing.
the
It's not,
law
it's a law thing. Yeah, that could be challenged.
because
That could be challenged because
right, if you look now at how HR policies are drafted, persons in most of these tech companies and these modern companies, they don't just operate on vacation day and sick days. They have mental health days. They have taxable days. And you have to move with the times because the jobs have changed.
But that
And
has, but that's, excuse me, but that's tied in with company policy because the Employment Act does not speak to mental health days.
Right.
things
So
like that. So if a
Right.
company has a policy that indicates that they would like their staff to provide a sick slip on a Friday and a Monday, that's a part of the company's policy that should be able to stand, shouldn't it?
no, but if I'm getting a sick slip for a Monday or Friday, you do realize that means I have to go to the doctor, spend $200 for a visit to get that slip.
right.
If I'm legitimately, why am I incurring that expense? When
But
the
like
law,
Ms.
it is-
When the
Bastian
law
said,
says I
if
don't
you
have
sign,
to, right, the law says that I don't have to.
but
I
you
agree with
sign,
Ms.
but
Archer.
you, but if by signing the in the employee handbook, isn't that constituting you signing a contract with the company? So
Yeah.
if you right, so if the company in the handbook says this is what we require of you,
Yeah.
and you sign that, you've signed a contract to state that I would abide by that rule or that
But Ms.
policy. So-
but because that's in the Employment Act or by law, can they do that, Miss Archer? I
Yeah,
think that's the question. Can they do that? Can they put that as a part of their
Right.
policy?
Because you're now putting on an expense on the employees. So is that really a benefit? If I'm entitled to 10 sick days, the
Right.
law, on the third day, I have to bring in a sick slip. But you're
Mhm.
saying I have to bring in a sick slip
On the first day.
on the first day of every first day that I do. That cannot be right.
But
But we
does it,
Yeah.
okay,
But
when
we
Miss,
do
I
that.
think, Miss Cox gave her example. She spoke to the employee calling in on the second day. Does the law say that he is required to call in, or does our company require that he calls in every day that he's out sick?
Yes, if
Yeah.
you don't
Yes.
have
The
a
company,
sick
so-
slip, you would have to.
But that's not by law, that's by your company policy.
That's
Right.
the company
Yeah.
policy.
Right, so there are certain requirements that a company imposes that when you sign your contract, you're saying, this is what I'm gonna abide by. And it's, whether it's in the Employment Act or it's closely related to, or bearing, I don't know. But if
No,
if the company
but I-
says, this is what we require of you, and you sign and say, okay, I agree to that. Then when you breach that, then there should be something goes against you.
Agreed.
So
Agreed.
that's, so the company says you
Yeah,
need to get a
agreed.
sick slip on a Friday, then if you get sick on a Friday, you have to go and get your sick slip.
But we also have two that we may ask you after on the first day to bring in a sick slip, because you may have someone that has continued to call in sick. Because we had someone every holiday, they were
That's a-
always sick before the holiday.
That's a different
Yeah.
issue.
So, yeah, so certain
Yeah.
things like that, we can require you to call in, require you to bring in a sick
Yeah.
note.
That's when you would actually send them to your doctor.
Well, they didn't go to our doctor, but they went to a doctor, the same doctor that signs off for all these stuff. They
Mhm.
use the same doctor.
Yeah, you normally, when you have someone who's frequently sick, you send them to your doctor to find out what exactly is wrong.
Yeah, but once we brought that to the attention of that staff, and we also had another one, that you're always calling in sick before holidays, it stopped.
Yeah, yeah. Because they weren't really sick. They just was using the
Right.
time
Yeah.
purpose.
Mhm.
But the thing is, whether or not that is reasonable.
So I have another question, just in a case that I had, the person filed for wrongful dismissal. Then they wanted to add unfair dismissal. Why would they choose to add both?
Because if they can't get it under one, they can get it under the other one.
Oh, okay, okay. I was wondering if it had something to do with compensation.
In a way, because first they'll go through the tribunal and then they can appeal to the Court of Appeal.
Okay,
Yeah. Because the tribunal only can hear matters,
they can only hear, what is that?
certain matters.
Matters.
Oh, okay, yeah, because it did say that when they first applied, they applied under wrongful dismissal, and then they wanted to add in the unfair dismissal, but the Court of Appeal, sorry, the tribunal said that they could only act on the first one, which was referred to them by the minister.
Yeah,
Okay,
that's the only thing that they can, I guess, act upon wrongful dismissal. That's outside of their ambit.
okay.
Yeah, so that's one. I mean, I have quite a few of these, but we don't have that time to look at all of those.
Thank
All
you, Ms.
right.
Archer, for giving me that one.
Yeah, like they keep complaining, saying, "Does anybody win?" I said, let me find one where someone wins.
Yes, thank you. Just so that it's fair and balanced, that's all.
This is not all the time do they win, but that one did. I think I had one. Hold on. Let me see. before, because Unit 5 is really on your capstone. Oh God, where I put that? I'll give you one with I don't know if I can put my finger on it. This one had to do with a medical facility. There was a doctor and some other people. That was a good one too. Maybe I could find it for when we have the next class after the midterm. I can do that one. I have one here where the question was, can vacation leave and maternity leave be lawfully relied on for summary dismissal? That was one. But you'll notice in most of these cases, they talk about the investigation. Anyone else read the case? I think I sent the case with the lady who's having the sex in the booth at work.
Yeah, that's me. That's Sherry Brown versus BPL.
That was good, right?
My
Oh,
word.
awesome. That was awesome.
Do tell, do tell. Who is
So
that?
they had a camera showing that? Or?
Yeah, it's on camera. It's on camera. I'm not 100 completed with my summaries because I wasn't prepared until for next week.
That's fine.
But yeah,
That's a
but
good one.
that's very interesting. Very, very interesting.
She had no shame.
And absolutely not. And the thing about it is, and there were other people in the booth. That's the part what's mind boggling to me.
They were having public sex with everyone watching? That's what you're saying?
It's like,
Wow, so there were
I mean,
witnesses. Wow.
yeah,
That's
that's the mind boggling part to me.
Did you give both of us that case? Because that's my case as well.
Everybody has
I
that
have-
case.
Oh,
Everybody has all the cases. Everybody has those cases.
okay.
Everybody.
That was interesting.
I know you'd like that one.
Yeah.
Let
I
me see.
don't understand people why they do what they do on the job. I don't understand.
And everybody could have seen this woman. She just
I
said,
know.
like this man a lot.
But she said there was no romantic involvement between the two. So that's the part what got me to. It's just very interesting.
Just like to have sex
Obviously.
on the job.
Obviously.
After been working somewhere for all those years, that's how you end it.
But after 24 years. And the thing about it is that Mr. Strawn, who is the investigator, and he was saying that there was incidents when, you know, what he said in the dark, or in other. So this was a thing actually. This other person would be doing it in the dark. The camera would show it. I'm like, who are these people?
Yeah.
She was a long time employee.
24 years. 24
right.
years of BPL.
Long-
Because that was her grounds. I mean, that's what she was saying for wrongful dismissal and for mitigation. She wanted mitigation. She wasn't given, you know, the opportunity to mitigate because of her being there at BPL and at least given an opportunity to cry mercy, I guess. And she was in the union also. So the union fought for her.
Mhm.
The union fought for her. Yeah, they fought for her.
But she did this right in the booth where everybody could see her.
Clearly. But she didn't deny that part. But at first she said, you know, they wasn't doing anything. And then the I think it was the HR person said, listen, don't let me have to talk your business in here. I could roll this camera for you. And then she admitted the next day that yes, she was guilty. She admitted the next day. But at first she was saying no, it wasn't her, because it have on there. She had consultation with Isaacs. I guess she was union president, may have been union president at the time. I'm not sure. Dot Isaacs, I think I can't remember her name. Dotson Isaacs or something like that.
Yeah.
So she probably told her, listen, come clean, just come clean. So, because the cameras clearly are there. So,
Yes, that was a hot one. We'll wait for you
Yeah.
for the next.
okay, okay, okay.
I'll see if I can find something else that is exciting. I don't know. Because we gotta look at some heavy cases to do with, have industrial agreements. Because we haven't had any with industrial agreements, so we're gonna have to look at a few with industrial agreements. And I have some. But it's a little bit more complicated, but we will see. But I don't have much more with employees want. They usually fail. I might see if I could find another one.
Well, this BPL Sherry Brown and BPL led me to look at the one for Helena McCarty and John Bull. I read that one because it was kind of correlating with that. The tribunal was making reference to that particular case. And this was a case where a manager, 14 years at John Bull, working at Michael Kors, Paradise Island, they had a promotional event and alcohol was involved, and she
Oh, yes, that's a good
drank
one.
two glasses of champagne and allowed her staff to drink 2 glasses and allow her staff to drink as well. And they were all suspended for 5 days. The staff came back, but she didn't. And when she came back, she was told, but she called, and the HR told her she was dismissed on a summary dismissal. And she was like, okay, let me get my money. And they said, no, you no money to get. And so she went to the labor board, and they said she didn't have a case. And then she went to the tribunal and she won. She got her money.
Yeah.
That was a good one.
Yeah,
That was a good one.
yeah, that was a good one too. Very good one. Yeah, so you see there are a few, but that woman in that boot, she was something else.
Yeah, she is something else. She is something else.
Okay, so Ms. Archer, like you said, so everybody got that BPL one assigned to them to read, because I had that one, and then I also had a Great Cliff one. So, okay, gotcha. The one
Yeah.
I had for BPL that I started to go to too, she got some monies, but not what she asked for. So it's depends on how you look at it. It's a win, but not what she wanted.
Yeah, she wanted more money. She
Mhm.
she wanted more money. I think the
Yeah.
union was telling her that she could get more money, but she didn't get.
Okay. Yeah.
But Ms. Archer, I'm the one presenting. I just want for clarity. I'm going to be the one presenting that, or
Let me look. I'm
because
looking.
you have Cartwright, and then you have Sherry Brown versus BPL.
Yeah, but I have one is BPL versus Sherry Brown. That's at the
Okay.
tribe. And then Sherry Brown versus BPL, the opposite way, is the Court of Appeal. So you're doing
Okay. Say it again.
you're presenting from the Court of Appeal case.
Okay. Okay.
And then Burnside will do it from the tribunal.
Okay. Right.
Right.
In the Court of Appeal. Okay. Let me just make sure now. The industrial, so if the industrial tribunal appeal, employment law, unfair dismissal, damages, right to mitigate.
Let me look at the copy. Where's Sherry Brown? Okay, so the one that says at the very top, Industrial Tribunal Nassau. You see that at the top on the left-hand side?
Yeah, no, I don't have that one. I have
You have the one
Commonwealth of
that's
the Bahamas and the Court of Appeal, Commonwealth of the Bahamas and the Court of Appeal.
yours.
That's mine. Okay. Okay.
Yeah, Burnside will do the one that says Industrial Tribunal.
Okay.
Yeah,
Okay, no problem.
yeah, so that's that. I have others, but we'll We'll see how it goes. Okay, so module 5. Hold on, let me see something. Where's my paper? So that you all could feel kind of good. My exam paper, let's see. What's that? I thought I wrote something here on that. I just seen if I didn't take it out. Yeah, I have it here. All right. So module 5, there's only 1 point from that chapter, because don't forget the capstone is based on you actually working on the performance appraisal. So I didn't pull any questions from module 5, except one related to references. So in the midterm, there's a request for a reference letter for someone who was dismissed for dishonesty. And in the employment contract, it speaks to the employee being able to request a reference letter. And I need you to discuss how would you approach that?
What, can I ask, why do we, can't even speak. Why is it, reference, or why is it called a reference letter versus a verification? Because to me, I feel like reference is almost as though you're supporting, right? Is that
Mhm.
just a general term?
That's
Versus
just a,
just because it's more so to me a verification letter. You're verifying that this person was employed
yeah,
during this
but
period of time versus it being a reference. Yeah.
yeah, they normally call it reference. But it is verifying their employment, start, end date, sometimes salary, sometimes specific job functions. So in your midterm, you have a question. That's a part of a question. So that means you're writing a whole Bible. And all I'm asking you is, how would you approach that? This person would have missed, and now they're asking you for a reference/verification letter.
So this person was, you said this person, the person was dismissed for dishonesty?
Yes.
Okay, okay.
Ms. Archer, I should enjoy that question because that happened to me.
Okay, so that's a part of a question.
Yeah.
It's not a whole question. So the midterm has 5 questions. Each is worth 20 points. There is a bonus, and the bonus has 3 questions. Now, let's see how we are going to approach these. Remember the case of Esther Fox and the Ministry of Labor and parliamentary registration and the Attorney General?
I don't remember that one.
Last
Yeah.
week, the one who, she got robbed.
Yeah.
Oh,
Yeah.
yes.
Yeah. Mhm.
Okay.
Yes.
Okay. So write that case down. The case is on exam.
What is it again? Fiesta Fox?
Fox and the Ministry of Labor and parliamentary registration.
Miss Archer, are the questions, I mean, how much quote unquote law are we expected to know and to cite? Is it that stringent?
No.
Okay, great. Thank you. Okay, awesome. Thanks. Okay.
Now, and then you'll see it's not like that.
Okay, I will trust you.
All right. So
And also the logist. No, I'll ask this question at the end. Go ahead, Miss Archer. Sorry, go ahead, proceed.
all right. So that's the case. The question is around the employer's statutory duty to ensure health and safety. So referring to that case, I want you to discuss the defendant's duty to use reasonable care to ensure safety of their employees. And an assessment of what risks are foreseeable. Remember in that case, the judge started talking about what is foreseeable when he said that when you look at all the other parliamentary stations, whether or not robbery had occurred of all of that, each one of them, could you then say that policemen should have been there at that time because other stations had incidents? You remember the key, that whole case turned on what was foreseeable. So if you're looking at the employer's duty of health and safety, the judge argued about what is foreseeable because the police were not there, but they were still there. She heard the knock and she ran and opened the door. So he's saying, looking at health and safety and the employer's duty and assessing the risk that something can happen, what is foreseeable? So your answer is going to be taken from Esther's point of view. What were her challenges in trying to sue one of those parties because they breached their duty of health and safety?
We're taking Esther's point, but she lost.
Yeah, but that was her challenge.
Oh, you're saying, how could we have argued it better for her?
Yes.
I see you. Okay,
Mm.
gotcha.
Yeah. Okay. No, we can't make the same mistakes they made. Okay. So I've given you one. I've given you part of one. That's 1.5. In the case of Ricardo Hart and Odyssey Aviation, you remember that?
Yes, yes, that's the one when the wing got
Yes.
damaged.
Yes,
He
I
was
know.
the health and safety manager.
Okay. So in that case, it was stated that the sole remit of the tribunal is to gauge the fairness of the applicant's dismissal on the basis of his contentions. So I want you to discuss the employee's duty to the employer relative to this case. What was his duty to his employer? So the one I just gave you with Esther was looking at the employer's duty. Now on this one, I want you to tell me what was the employee's duty.
And Ms. Archer, when you say this, you want us to remember these cases? Is it open book or how does this work?
Book is not open. Yes, remember the cases. You're not
Okay.
citing at all. So as I'm giving you the cases now, so let's take this one with Ricardo Hart. You knew what his job title was. Based on the story we read, you knew what he was supposed to do, that he didn't do. That was on his duty. What was his duty as an employee?
He was the health and safety manager, for sure.
Yeah. And what was his duty as an employee? Under common law, he had a duty. What was his duty?
Oh, I can't remember.
To ensure just that.
Okay. So if you go back to that chapter, he had a duty to perform his job competently.
Right, right,
And
right.
remember when his boss asked him about the wingtip and the move, he was doing something different.
Right.
So also
right.
had to obey all reasonable and lawful orders. And then because of the type of work he did, he also had a duty to exercise reasonable skill and care.
Right.
That's what the question is asking you. Discuss the employee's duty to the employer relative to the case of Ricardo Hart and Odyssey. Okay. Now, remember the case of that wonderful friend of some of yours, Mr. Davis,
Yes. Kaylin Jervis and the Anglican Diocese.
right? So he argued that his boss had breached his fixed term contract. You have to explain what is a fixed term contract and discuss the standard terms and conditions of his employment.
Sorry, Miss Sachi, you broke up on my phone at the end. Can you say that? What is a fixed term contract? And I didn't get the last part.
And what were his terms and conditions of his employment? Because remember, his whole argument was with the handbook, where it was a part of, okay,
Yes. Yes.
on terms and conditions of his employment
Yes.
and what fixed term contract.
Right.
Now, all the questions that have a part B, that part B is only worth 5 points. So do not spend forever and forever writing a long epistle. Made a note of that?
Yes, thank you.
All right. So another one of those little 5-point questions, because I gave you one already, which is the one on the HR and the reference letter. Another 5-point question is, can the industrial tribunal go behind the minister's certificate of referral and vary it? Can they do that?
I'm sorry, you broke up. Can it go behind what?
Can the industrial tribunal go behind the minister's certificate of referral?
I don't remember us discussing that.
No, we did not.
That was in my case. I remember that being stated in my case.
Yes.
Yeah, that was in my
And-
case.
Ask you to refer to the Industrial Relations Act. It's a 5-point question. Another 5-point question. Can the vice president of the tribunal come to a conclusion without the employee giving evidence? Can the vice president of the tribunal come to a conclusion without the employee giving evidence? Hint, the Industrial Act, Relations Act. You remember that case called Brandley Mortimer Roberts and Perfect Luck?
That was one of our
Yeah,
first ones.
I have, but I didn't read it. I didn't read it as yet, but I have it. I'm sorry.
That was mine, I think.
Yes, it was. And that referred to an employee's duty of mutual trust and confidence. and it is frequently relied on as a basis for dismissal. And I want you to explain this duty of mutual trust and confidence and the rights of an employee to his employer, referring to the case of Brandley Mortimer and Perfect Luck.
Explain the duty of mutual trust and confidence.
And the rights of an employee to his employer. Those rights are in your notes.
Okay.
I think we also did the case of Commonwealth Brewery and Patrice Ferguson.
I don't remember that one.
I have to look at my list. This case has to do with the definition of supervisory or managerial.
Yes, we did
That
that.
was mine. Yeah.
We
Okay,
did that.
okay. So I want you to define what is supervisory and what is managerial, referring to the case of Commonwealth Brewery and Patrice Ferguson.
Define what is supervisory.
And managerial. Because it's not defined in the Employment Act. So you had to go to case law.
What's the case again?
Commonwealth Brewery and Patrice Ferguson.
Okay.
This is one where she transitioned from one role to another, right?
Yes, yeah.
Mhm.
Commonwealth Brewery and Patrice Ferguson.
Mm-hmm.
Okay.
And then you have 3 bonus questions.
Ms. Archer, that was a 15.1?
Yeah.
Okay.
Yeah, so when you look at the exam next week, you'll see some of the questions of a B that's only worth 5 points. So don't spend a lot of time. The bonus is very easy. Only one of the questions refers to a case. So one of the bonuses on the court structure and how does the bill become an act. One question is on let me see how would I word this? The duties of the Minister of Labor when a matter comes to his attention. What does he do with it? And the third bonus question is on the case of, and you know this one, Eight Holdings Limited and Jessica Grant and Wendy's. And it's just asking you to explain how to join a party to an action.
Say it again.
How to join a party to an action. You remember that case, right?
Yes, ma'am.
Okay. So you have 5 questions, 20 points each. Some have a part and the bonus question.
So Ms. Archer, what are the logistics of this? We're coming in, is that correct?
Yes. Mm-hmm.
Can you repeat that, Miss? I didn't hear the question, Mr. Clark.
Oh, the exam is in the office, in the school office, on the premises.
Oh, okay, okay.
It's gonna be on a Saturday though, right?
Mm,
Saturday? Oh, I thought it was one of our Wednesday nights.
I think, hey,
Okay, sorry, I thought Miguel said that they usually try to do them on a Saturday,
find out. I
but
can find.
okay,
Let him send an email.
okay, thanks.
Yeah. I'll ask him. I'll send that to him right now.
And a colleague of mine took this last year and her classes were on a Saturday. So I know she took hers on a Saturday, but that was also aligned with her class,
Mm-hmm.
her
Yeah. Okay.
courses. So I thought ours was gonna be on a Wednesday.
Great. Okay, hold on. Because on my calendar it says the 15th. So I'll just send an email. Find out when it is, and then let them send you all an email tomorrow.
What is the passing
Thank you.
grade for this course?
70.
Okay.
Okay. Let me put it in now. We put midterm so she don't make it, Okay, I sent that. Find out what that is so they can communicate that to you.
Okay, thank you.
So everybody is clear now. So there's no legislation for you to write. You're just explaining different duties of an employee or an employer, or you're discussing definitions that are not in the Employment Act, or like you're looking at how the courts came to determination that first Esther didn't add on the right party to the matter, and then how the court looks at the employer's duty for health and safety when they said that the risk was really what was foreseeable. So like I told you,
Not Esther, it was Jessica, wasn't it?
No,
What-
Esther.
Esther,
Esther didn't,
Yeah.
Esther didn't add on the right. She didn't, yeah. Remember, we said that.
Or
She
Wendy?
just- Jessica, Esther was the one with, when she got robbed, when the place got held up.
Oh, yes, 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 yes,
So
yes.
she should have had.
But I think
for
there was
the-
some
the
question
commissioner
about the
police.
Wendy's and Jessica too.
No, Wendy's.
It was just us.
They was
It was
under
just,
Aotis. It was Aotis versus Wendy's. And so it was to be, it was to be a
oh, you know what? It
joint-
was
a
their, it
joint
was
thing.
their argument that she had.
Yeah.
It was
Uh-huh.
their argument. Yes,
Yeah.
yes, yes. And it was something related to positions.
Right.
yeah.
Because Wendy's was the one but joining a company.
Aotis, with
party.
Aotis, yeah, Aotis.
Yes. Mm-hmm. So I'll find out when your exam is so they can send that to you tomorrow, and then you will know. So no one should be
Sounds good.
no one should be confused. No one should go in the exam and sit there and can't figure out what to do. The names of the cases, especially for Jervis, is written on the exam. Ricardo Hart and Odyssey, the name of the case is in the question. The one on Esther Fox, it is written in the question. And the other ones, you'll be able to figure it out. Where you don't see the name of the case, you know the case that deals with supervisory or managerial position. And you know the case that deals with mutual trust and confidence. You know that case also. The Brandley, Mortimer, Roberts, and Perfectly. So there's no need for anyone to be confused in the exam. Everything is, as I said, there are no surprises. Any questions?
It is a lot, Miss Archer. I just want to go on record. I might be speaking for just myself, but it
No,
is a
you
lot.
are definitely not. I was really
I was
thinking
wondering
that
if I
just
could hear
now.
anyone else give me
You
some support.
can. I am thinking about all these cases and just having to remember every aspect of each one
No,
and
it's not,
which one it applies to, and you know, it's a
no,
lot.
it's not every aspect. You're thinking too deep now.
I'm
If
gonna
you
trust you, Miss
Yeah,
Archer. I'm
but
gonna trust you.
at Ricardo Hart and the plane, the question asks you, discuss his duty to his employer. What is his duty? We just went over this. What is his duty as an employee?
No, that one I think is more one of the more memorable ones.
But what is his duty?
To perform his job with a competence, with a level of
Yeah.
competence.
What else?
Duty of, I don't know, care.
Reasonable care, skill and care.
And one more.
I don't remember the last one.
That was the one when he was doing something, when what he was supposed to do, he wasn't doing.
He wasn't paying attention. I thought that was
So
duty
he
of
had
care though.
all reasonable and lawful orders.
Oh,
Competency.
Yeah. So all you have to do is the duties of an employee to an employer, as demonstrated in the case of Ricardo Hart, was that, and that. In that case, he was asked to do this, but instead he was doing something else. And the court ruled that, yes, he should have been terminated. That's it.
okay.
The whole 25. I want to see that you understand, based on the case and applying the common law, what was his duties? And you demonstrate that by telling me his duty was to do this, this, and this. This is what his boss asked him to do, but he did that instead, and he was unsuccessful. When you look at Jervis, he had a fixed term contract and he had terms and conditions of employment. So you would say that he had a contract, you'll define what is a fixed term contract, and then you would state that according to his terms and contract, there was a reference made to a handbook, one in which he said blah, 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 la, 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 and then that's it. I don't need to know, but him truck turning over, him slapping the student, none of that is relevant.
Okay, that's helpful to know. Okay,
Just
good.
answer the question that I'm asking. That's it. Don't forget, all the rest of that is all of his issues and why they came to the conclusion. No, we're looking at what is an employer duty? I mean, what is an employer's responsibility to the employee? And what is the employee's duties to the employer? And what is the employee's rights? So this is not sitting there writing out a whole kennel of words. You don't have to do all of that. All you really doing is explaining or giving your examples based on the cases.
Okay, fair enough.
Yeah. And then, like I say, 2 of the questions don't have the cases mentioned, but you know, based on the cases that I've given you, what those 2 cases are that are not there. So when you read it, you'll say, okay, these two cases are missing. One goes here and one goes there. And you just write it. So it's not, and you have 3 hours. So it's not that much. I don't want you to be writing the whole Bible. No. I just need to see that you understand the employment law principles. And that's it. Okay? So if
Okay.
anybody-
Thank
Yeah.
you. Mhm.
right, if anybody have any questions or start to get muddled, you can send an email.
Okay, thank you.
Yeah, you can send an email if you get a little muddled or confused. All right?
Yes, ma'am. Thank you.
Will
So good.
do.
I know you all will do, so I'm not worried. I
We'll
think
do
you
our
all-
best.
I know you will. I know you will. And I made sure I picked the cases that were the most interesting ones and the ones that you all will remember. I did that intentionally. I remember everybody loved Jervis, and some people knew him personally. I know with Ricardo Hart,
Yeah, I know him personally.
yeah, I remember you all were all saying, oh my God, this man with the plane and then the tail get knocked off, and he kept doing what he wasn't supposed to do, playing with the rug on the ground. I don't know why. And he was distracted. And the one with the Esther Fox and parliamentary registration. I mean, I don't know why she was still there. The police are gone, but she was still there. So I mean, just when you see the names, the story should come back to you. So I don't think it's that much. You let me know after you take.
Oh, yeah.
You'll let me know. But the final will be the same way. I will tell you what's on the final exam. There are no surprises.
Okay, that's fair. Thank you.
Okay, so let me just find out exactly when this exam is to take place, and then you all can go from there. So while we start studying now, and for those who didn't read the cases, it's a good time to get started reading the ones that you didn't read, so that when the exam comes, you don't have to sit there trying to find words. Okay?
Yes, ma'am. Thank you.
All right. Okay, so good luck.
Thank you.
Thank you.
Thank
Good
you.
evening, everyone.
Thank you.
Okay.
Bye-bye.
Good night. Bye-bye.
Good evening.
Good evening.
Evening.
Good evening.